Hi, everyone. Welcome to another episode of our AI Governance Live Talk. So today I'm here with Andres Guadamuz. So welcome, Andres. He is an associate professor of IP law at the University of Sussex. He's also the editor-in-chief of the Journal of World Intellectual Property, and he's an internationally acclaimed IP professional. So welcome, Andres. I'm so happy to have you here.
Thanks very much for having me. It's both an honor and a pleasure. A big fan of your work.
My pleasure. Before we start, so some practical issues. So if you want to stay up to date with everything AI governance, also to stay up to date with the next AI governance live talk, so subscribe to my newsletter, luizanewsletter.com. Also, if you want to join the next AI governance training, so the January sold out, it's already started, so you can join the February one. The link you can visit our website, so aitechandprivacy.com. So you see under my name, and you can register for the February cohort. Now let's get started. So we're discussing AI and copyright infringement. So what is this intersection? Why is copyright relevant when we talk about AI? So let's use as an example ChatGPT. So ChatGPT is an example of AI chatbot. And how is it trained? So it's based on an AI model. And to train the AI model, companies usually, so they want to train large language models, they will scrape the internet and kind of digest everything that is on the internet to train that model. And when you digest everything, so they're also using copyrighted works. So for example, books, we'll talk about today some songs and other types of sources to feed this AI model that will power the AI chatbot. So this is what we're going to discuss today. So there have been various lawsuits. So if you're paying attention to the news, so you know that in the US, in the EU, I saw also Canada, India, other countries, there have been lawsuits. And what are those lawsuits? Well, basically are the creators, sometimes is news media companies, sometimes music companies, sometimes book authors, visual artists, all sorts of creators. They are suing those AI companies, so companies developing AI models and AI systems, because they're saying, listen, you used my copyrighted work to train your AI model or your AI system, and I didn't consent. I was not compensated. And sometimes they also say, so the output is infringing, so it's competing with my own work. So they are suing for various legal reasons, legal arguments, and that's what we're discussing today. So what are those issues exactly? So is it copyright infringement? What are the precise arguments? Is it only in the training phase, also in the output phase? Also, we want to talk about some other issues, such as if I use AI to create an image or a literary work, can I copyright that work? So these are the issues we are discussing today. So I hope now everybody more or less understands the topic. So let's get started with some US lawsuits. So the first one is New York Times versus OpenAI. So I'll let Andres, he knows everything about this lawsuit. So I'll let him talk a little bit about, especially focusing on the main argument. So what is each part saying, and maybe who is going to win this lawsuit, and what the audience can learn from this lawsuit.
Thanks. First of all, if I knew who was going to win the lawsuit, I would be picking lottery numbers, probably. It's some of these are extremely difficult to discern. So, first of all, I do want to mention I'm not a U.S. lawyer. I've been studying the cases and following some of them. As you mentioned, there are 38 cases right now. Ongoing. Three of them are privacy cases, so maybe about 34, 33 years copyright ones. But usually the New York Times case is a very good one to start because it sort of has a little bit of everything that we're looking for. So what is happening is that these companies, as you mentioned already, are ingesting large amounts of works that are often protected by copyright. There are people that are working on public domain, Creative Commons, sort of open source stuff. So the vast majority of the commercial models are being trained on works that are protected by copyright. And that means that there has to be an ingestion of these works. And for this to happen, there has to be a copy. And this is always, they're going to have a copy stored in some place. And then they're going to extract some information, some mathematical information, and then they're going to train the model. there are arguments of whether or not the copies are kept. For the most part, we can assume that they're not. But most of the cases, and particularly the New York Times case, is the New York Times are arguing, okay, you went out and with crawlers, you crawled our website, and you have been crawling and copying our articles. That is copyright infringement. And therefore, you have to pay us a license. And there were actually negotiations beforehand in which Microsoft and OpenAI were trying to negotiate some form of fee. Some of the companies have actually been paying some publishers. Kluwer, if I remember correctly, was one. Springer was another. I may get. I'm pretty much Springer was one of them. The ones that had an agreement. So there has already been some agreements made. So the negotiations didn't go anywhere, and New York Times sued. The lawsuit was very interesting because it was one of the first. Actually, it was the first case that I know of that was able to present outputs infringing as well. So New York Times argued, not only did you copy our works in the ingestion, in the input phase, you also made you're able, or your ChatGPT is able to reproduce and regurgitate, almost was the word that was used, large chunks of our articles. And they had a large number of examples of this happening. So this was a very, very interesting case because of this reason. It's still ongoing. The defendants are mostly arguing fair use, which we can go into that a bit later. But most interesting as well, there is an argument that from the defendants that the technology itself has non-infringing uses, and that brings us to lovely cases from far from the past. The Sony Universal case, in which the Betamax technology was capable of infringing copyright, and people were able to copy videos in their homes, and that was considered to be a technology that, even though it could be used for infringing, it also had substantial non-infringing.
I think.
Yeah.
Say. No, I was just saying that at this point, especially so that we organize the thoughts for the audience. So maybe we could start with split in three parts. So we start with the input phase, so the training phase, right? So sorry, the input phase of the training phase, where the AI company is ingesting the copyrighted work or New York Times article to train the model. So what could be the pros and cons? So the OpenAI is saying that it's just a background process, right? It's not really copying. It's just this AI system or this AI model that ingesting this data to learn the patterns, right? They say it's not real copy as copyright law sees it. We are just, the model is just learning the patterns. It's not real copy. And what New York Times says, no, this is copy. So what are your thoughts especially regarding the fair use part in this training phase?
So there is a copy. I don't know of any system that is not trained using a copy. You can split hairs a little bit. You can make arguments that this is not really a copy, that it's much like a human when a human reads. I've seen this argument used, that is exactly the same thing. It's more, because it's a computer, you have to create a copy in the machine. So if we start with that assumption, and we understand that there's a copy, we have to look at the exceptions and limitations that copyright has some exceptions and limitations. So in the case of fair use in the United States, there are 4 tests on what is fair use. So the first one is the purpose and character of the use. So things of whether or not the use is socially valuable or if it's transformative. So let's say you're an artist and you create a collage, you take part of a picture and you have transformed it. Means potentially, but that's potentially a different one. The second one is the nature of the copyrighted work. So very creative works are going to be less likely to be under fair use. So things like information, data, sometimes perhaps even news, factual stuff may have it may be easier to make an argument on fair use. The third one is the amount or the substantiality of the portion that was used in relation to the copyright work. This is going to be a tricky one, I think, with the training, because are we using the substantiality in the final or in the ingestion phase? So the entire article was copied, let's say, in the case of the New York Times. And the final one is potentially going to be very important in some of these lawsuits, particularly in some of the audio lawsuits, is the effect of the use upon the potential market for the value of the copyright work. So if what you are creating has the potential to compete heavily with the work, with the copyright work, that is less likely to be protected under fair use. So those are the four. As for what may happen in this case, your guess is as good as mine. I've read opinions from legal experts on both sides. I've been on record from the start saying that you can flip a coin, perhaps in some of these cases, because an interesting statistics, perhaps that is good to give now, is that in average, 60% of cases, civil cases, and all of these are civil cases, in the U.S. are settled out of court, negotiated out of court. And that means that potentially some of these cases are inevitably going to be settled. So I have my bets on which cases may be settled. Actually, the New York Times has always been very high on my list of potential cases that may be settled, but I don't know. Nobody knows. Whoever tells you that they know what's going to happen is lying to you. So generally speaking, I don't know. I think that the New York Times has a strong case. I think it's probably one of the strongest cases, just because they were able to reproduce some outputs. They were able to prove, look, you're actually regurgitating some of
And just connecting the fair use, the four the test that we go to try to understand fair use. I think I would jump to, we will go back to Dow Jones and Udio and Suno lawsuits and Jason Allen, but I want to skip briefly to Anthropic versus UMG and other music companies. It was a recent agreement, and I posted about it, and I discussed today in the newsletter. So I think it's nice to discuss the fair use part and maybe how we can understand, especially one of the fair use tests that we say, okay, is not competing. So for those not aware, so this is another lawsuit. It's still ongoing, but there was a recent, decision within the lawsuit in which, so it's Anthropic versus Universal Music Group and other music companies. And so those music companies are saying that Anthropic, in order to train Claude, they scraped the lyrics of the songs and it's being output. So this is the copyright infringement. But during this lawsuit, there was an agreement. So recent now, right? The first there was the January 2nd, and where they agreed that Anthropic, so they have these guardrails. So they have implemented technical guardrails to avoid copyright infringement. So while the user is typing the prompt, it looks like he's doing input and output. So everything is not at the training phase. So if we were thinking about training phase, so it's nothing at the training phase. It's during deployment. So while people were prompting Claude, so they have implemented some sort of guardrails. We don't know exactly what they are and how effective they are, but Anthropic has implemented those guardrails, and supposedly those guardrails are good, and they can be implemented when the user is prompting. So those guardrails, they avoid infringement. And what I said that I wrote in the newsletter today is that my view, and I know some people disagree with me, and I've read some of the comments where people don't agree. My view is that Anthropic was very smart because the judge, because of this, is not the end of the lawsuit, but both sides agree that, okay, these guardrails, they exist, they are a legal and a technical mechanism to avoid copyright infringement, and at this point, Anthropic should keep them and avoid copyright infringement. So now going back to what you were talking about, fair use. So if we end up, and what is the hope here? So everybody, since the beginning, I've been discussing AI copyright lawsuits. It's a big hope, right? If you have an AI company and you make sure that, I don't know, 99.99% of the outputs will not be infringing, or 100%, there will never be an infringing output. The fair use test would probably be more favorable to the AI company. They would have a stronger case for it is just a background process to train the machine. The machine will never output anything infringing, and it's never going to compete with the original creator. And it's just the machine which is seeing it, nobody else. So what are your thoughts both on this agreement between Anthropic and the music companies, and the potential? Is it going to be a precedent? So everybody's going to, okay, so every AI company now has to have this guardrails. So implement technical guardrails, make sure that they follow standard X, Y, and Z, and that's fine. You do whatever you want during the training fields. What are your thoughts?
Yeah, I agree. I agree with you that I think that this is very interesting. It's very interesting development. We are at the stage where we can expect little agreements like this. As I mentioned, this is potentially what is going to lead us to some of these cases being settled out of court, because something that companies and from both sides do not want is a bad decision for their side. So when things start getting even outside with the jury inside the room, there is potentially going to be quite a lot of negotiation. So this is a good indication that potentially there can be a bit of a give and take, because as you mentioned, if these processes are in the background and all of the potentially infringing outputs are under guardrails, that would mean that there can be a negotiation, potentially eventually some form of licensing agreement as well, which I think is potentially going to be, we can talk about that a little bit later, but when we're looking at how the end game looks, that could be guardrails, a combination of licensing, guardrails, collective licensing agreements, and all sorts of things, but also application of some exceptions and limitations under some cases. Not every single case is going to be fair use, for example. In this case, I've always thought that it had a potential for fair use. People can disagree with that. At the moment, as I mentioned, it's sort of a little bit of 50-50. Perhaps because it would be good to explain some of the cases just briefly. So there are probably going to be two main cases. There are lots of cases on fair use, but the two main ones that may come into play are Google Books. Neither of these cases are related to AI. But Google Books is probably the closest. Google Books was Google was doing a large amount of digitization of books, and the argument there was a fair use because it was all in the background and there was a potential. It was commercial. Google was definitely having commercial operations here, but there was transformative. It was considered to be highly transformative because the books were being digitized, but also, most importantly, is that there wasn't a feeling that it was going to impair the sale of books. Actually, there were some economic studies made that if your book showed up in Google Books, it was actually more likely to be purchased. So it's potential that these cases are going to be like that. The second one is the more recent one, is which Andy Warhol, in which Andy Warhol Foundation was sued by a photographer. Oh my God, I always forget the name. And the photographer won. That the Andy Warhol Foundation claimed that this was transformative use, and the U.S. Supreme Court disagreed. So it's very interesting that we're going to see. It has narrowed down considerably what is considered to be transformative use, and we will know. We're starting to see hints of a Warhol being applied in some of the early decisions. So we haven't had a full decision in the US, but we are starting to see that these two cases are probably going to be very, very important in this.
And before we continue, you want to explain your T-shirt?
Oh yeah, yeah. So this is there's a. Sorry, I'm very colorful today. I'm in
You
Costa
want to
Rica.
tell the audience where you're connecting from today, Andres?
Yeah, I'm connecting from Guanacaste in Costa Rica. So you may actually be hearing this sea is right in front of me. I didn't turn the camera because I didn't want to be cruel to people who are in Europe. Uh, in the cold, but most importantly, this is not only a fashion statement. It's a very interesting T-shirt or shirt because for those of you who have managed to observe, it's Ultraman. And Ultraman is now famous in AI copyright because it was the first copyright infringement case to be decided in favor of the claimants. So the uh, um, uh, Japanese company sued the makers of an image model in China for copyright infringement because the model was able to reproduce Ultraman. So it is not only the first copyright infringement case, it's the first copyright infringement output case, which is also very interesting. We've always thought that it was probably going to be inputs that were going to be the first case. So yeah, that's the reason. And some people may be thinking that it's a dubious fashion statement, but hopefully that explains a little bit more.
Is super connected to our topic today. So let's continue with another lawsuit, the recent one also. So Dow Jones and New York Post against Perplexity, so that we are changing between AI companies. We're not always with OpenAI. So what I think it's interesting about this one. So they similar arguments. So there is the fair use. So Perplexity is arguing fair use. Dow Jones and New York Post are talking that no, it's not for you, not fair use. You're scraping our news articles to train your AI model and your system. But what I think is interesting from the claims here, so they have 4 claims. So summarizing the claims is infringement during input, infringement during output. Mm-hmm. But then they talk about brand harm because of hallucinations. And I thought that was very interesting. So as one of the claims in this lawsuit, so Dow Jones and New York Post, they say that sometimes, like we know that AI systems, they hallucinate. For those in the audience, so hallucinating is when you're asking something. Let's imagine, what books did J.K. Rowling publish, and then comes Harry Potter, and then other invented titles that have to do with a topic of Harry Potter, but has nothing to do with what J.K. Rowling has published. So hallucination means making things up. So that this is, we thought at the beginning of this generative AI wave, so November 2022, we heard experts saying hallucinations are going to be solved soon. We will have 100% accurate AI systems. And we are more than 2 years in this generative AI wave, and hallucinations haven't been solved. So there isn't one, to my knowledge, there isn't any AI system that whose developers say it's 100% hallucinations free. So I saw also some tech executives saying that is not a problem, is actually a feature, is part of how the model works, and the hallucinations will stay there because that's how models, at least at this point, how the technology works today. So in this lawsuit, they say, so Dow Jones and New York Post, they say that Perplexity sometimes hallucinates. And while they hallucinate about a topic, whatever topic, but then they attribute the fake articles or the fake information to their media company. So this is a type of brand harm. So within this context of copyright, I saw this brand harm, which is extremely interesting. So within this copyright lawsuit, they're also saying not only you scrape our article and then you attribute to us something that is our article with fake information. So you're harming we would not have published that, but then you publish something fake, so you invent, and then you attribute it to us. So this is one part that I want to hear Andres' opinion. And also, I think there is something really interesting about this lawsuit also. So Dow Jones and New York Post, at some point in the lawsuit, they say, listen, Perplexity, we even contacted you. We tried to have a licensing deal with you. We have licensing deals with others, and you didn't even answer us. So this maybe was a bad choice. And now we are here. We want our licensing deal. And on the licensing deals, and Andres briefly mentioned that, I think it's really interesting. It looks like for media companies, for newspapers whose articles are being scraped, they want licensing deals. I think that they have financial issues in their business model. So they are losing revenue from ads. This new business model with AI companies would probably be very interesting. So look, I don't think it's the same. I don't have the same opinion about creators, artists, musicians. This is something else. But for news media companies, it looks like they want licensing deals. And in this lawsuit, it's funny that they say, like, you didn't want to talk with us about licensing deals, so we are here suing you. I want to hear your thoughts on both. So the brand harm part. So what do you think? Maybe it's not necessarily
Yeah,
connected to copyright and the licensing deals.
yeah. I do have to declare I'm not a trademark lawyer, but they're bringing the dilution argument, which is our brand is being diluted. So first, there is a false attribution of origin, um, in that you're saying all of this made up nonsense sometimes is being attributed to us, and that can be a harm damage, but also dilution, which is a very specific, and I'll let trademark lawyers in the audience. I've seen a couple that I know are already in the comments that are better at trademarks than me. But it could be an interesting argument because already we are seeing that the companies are worried about some of the hallucinations having a detrimental effect on people. You may have heard that there are some names that ChatGPT does not. You ask it about specific people, and it doesn't. It freezes. It gives you an error message, and that is mostly related to defamation threats. So there are people who have been involved, even not directly on defamation, but sometimes indirectly. There are two law professors who have been involved, Matthew Sag and Jonathan Cetrain, whose names you you can put them on ChatGPT and it doesn't work. So the companies are worried about this because it could be legal issues for them. And I think that potentially this is going to end up with a licensing agreement that you mentioned is very, very strongly implied in the lawsuit. And it's also a very interesting case because Perplexity is a little bit of an interesting example because it's not only an LLM, but it also has an index. And if I remember correctly, that was called retrieval augmented generation, a RAG, which is what makes sort of the results more search engine like. So you are Perplexity for something, and you get sort of the typical LLM activity, but also very specific stuff that is fine-tuned from index information from high-quality sources. And that could be newspapers and all sorts of things. And this is where licensing would come in. So it's very interesting in that respect. I think it's going to be a very unique case in that, because what Perplexity does is very similar as well to what Google is doing now with their searches, if you want to think about that. And one of the arguments in that case, potentially, that will have also interesting repercussions is that Perplexity is stopping traffic from incoming to companies, which is also in the lawsuit. But other than those arguments, I think that the dilution argument is very interesting. I don't have the expertise. Maybe you'll have to have a conversation with a trademark lawyer because there are a couple of other trademark related aspects. One of the artist cases is going to have some form of trade dress issues, and the Getty Images case also has a trademark element, which is some models, particularly Stable Diffusion, was able to put the Getty Images logo. Sorry, I'm doing this on the screen. The Getty Images logo when you asked for something with Getty Images, which was considered to be potentially harmful for them. Yeah.
And on the Perplexity one, you mentioned the aspect of indexing that works like a bit like a search engine because it attributes. So I maybe you. By the way, just a side comment. So if you see under Andres' name, there is written his blog. This is an excellent. How many years do you have the blog?
20 years in October last year. So yeah,
20 years. Is it you cover copyright or IP in general?
mostly copyright. I used to do more software patents and open source software before, but it's been mostly um, AI and blockchain NFT stuff, which I always found fascinating. I don't believe NFTs are the future by any means, but legally I found them fascinating. So that's the other topic I can talk for hours about.
So people can subscribe or they can just visit your. They can
Just
subscribe.
visit. I'm
Visit. Okay.
old-fashioned.
But
I'm what is known as a boomer blogger.
you
I,
should
I
transfer
I don't do
my
subscriptions.
newsletter on this. Okay, so visit his blog. Technoliama is under his name and under his name. So just going back to the Perplexity case and the fact that it's also types of indexer. So in my newsletter I see more and more sources. Maybe you have in your blog too. I
Yeah,
check the analytics and I see more and more Perplexity. So the
yeah,
source people found me on. They were searching for something on Perplexity and they found my article. So they get to me. So for me, this is, and in the lawsuit, Dow Jones and New York Post, they argue that Perplexity is bad because it's kind of stealing their subscribers. Just because if you have the paid version of Perplexity, you have more, so it's kind of stealing the. So those it will be interesting to see the outcome. For me, it's good. I see okay, the Perplexity is training their system with my articles. Probably everybody else is training, but people are finding also my newsletter and subscribing to my newsletter from Perplexity. So it's interesting to see how the judge will look at this case.
yeah.
Let's move to. You want to say something more about it? Can we move to
No, no,
audio?
no. I think we've covered the, yeah. Uh, you'll have to bring in a trademark lawyer for the second part. But yeah, it's
No.
fascinating. I think that they have a very interesting case. I don't know how strong it is, but yeah, it's interesting.
And the next lawsuit, so we have for those in the audience, so for those who are not as nerdy as us, we have two more I want to talk about with Andres, two more lawsuits in the US, and we move to the EU. So we have the Udio and Suno, and then Jason Allen versus Copyright Office, two very interesting lawsuits to discuss the main issues. So this now we are switching we spoke about the news media companies. Now we are moving to music companies. So major record labels, so the biggest in the world, I think probably, I don't know the percentage, but a very large percentage of the music industry. So major record labels are suing the two most popular AI music creation companies, so Udio and Suno. So if you haven't tried those, that's how it's. So you prompt it, and the system will create a song. So let's say you say, I want a song about AI regulation in the style of Taylor Swift. And then maybe you type more about how you want this lyric. Should be about AI regulation. It should cite A, B, and C. It will output both the song with the musical patterns and also the lyric. So, and then major record labels are suing them and saying, listen, you used our song. So we have the copyright. We are the copyright owners of those songs, and you use them to train your AI music creation systems. And what is interesting in this, so first I want to hear from Andres if there is something different. So here we are not talking about books and images, we are talking about music. So maybe there are cases, and the copyright lawsuits in the music industry are very interesting, right? So, sometimes I bring this discussion in my training program, and there is a heated discussion. So some people think that that's the nature of music, right? So even musicians, they're all time getting inspired. If you're a musician, you learn how to play, and throughout your life, you're getting inspired by other artists. So when you create your own music, it's going to be heavily inspired by others. There's no 100% original. So some people are kind of have this view of music. So first, from a strict legal perspective, I want to hear from Andres. Is there something different from a legal perspective when music is involved?
Strictly speaking, no. There is potentially what is going to happen is the same thing that happens with text. You need large amount of content. That in the case of music is large amount of music, and in the case of Suno and Udio, they have been very forthcoming that they have been copying tens of millions of songs and copied them in the background to extract information, and that is their attempt at doing the Google Books defense. It's all in the background. We're extracting information. It's highly transformative, and then people can create their songs. It's interesting because music copyright can be very interesting in the sense that, for the most part, being very similar or being in the same genre of another song is not necessarily copyright infringement. There have been very interesting cases on this. Katy Perry, Ed Sheeran getting sued all the time for his music. So similarity necessarily does not mean infringement, but there's a line that is crossed at some point. But that is on the outputs. So the lawsuit is very interesting that they were able to produce very similar outputs, but in the complaint, the music companies say these are not. We don't claim that these are infringing copyright, because they don't want to imply that very, very similar works potentially could be subject to copyright infringement, because they represent lots of artists that get sued all the time. So there is a very thin line on whether not something is infringing copyright music. So that is the only difference. But when we're talking about the actual training of the AI, the legal issues are going to be the same. Was there copying? Yes. Is that copying the fair? Is that fair use in the US, or does it fall under any of the other exceptions in other countries? We don't know. So,
and in this lawsuit, the plaintiffs, they say, so we are, no, sorry, the audio and Suno, so the defendants, they say, we are just using the patterns, the musical patterns. So that's if you were technically, so the record labels are saying you are copying our songs, you didn't ask for, you didn't license those songs, you didn't pay us, and you use it to train your AI system, which is for profit, and you're monetizing our songs. So we should authorize or receive the money or license those songs, and we didn't do that. But then Udio and Suno, they say we're not copying, we're just using the it's always the same expression, right? The style, the patterns. So we are just training. There is a background process, as Andres was saying. And what is interesting, and I was talking about that with Andres in this case here, Udio and Suno. So as Andres was saying, so the founders, I think is I forgot his name now. So the founder of Suno AI, he was really open about that. So he wrote a blog post and he said, listen, we are the new generation of musical. So some people in the audience might remember that. So a few decades already, it was Napster and Casa, what was the early 2000s? What was it? Anders, remind me, what year was that?
The Napster case was 2000.
2000, yeah. So if maybe
2000,
some of you
2001 with the appeals.
Back in time when we were younger, if you wanted to listen to a song, you bought a CD, or even before you had the cassette. But let's start with the CD. So you used to buy a CD to listen to a song, and then came some companies. Some famous ones are Napster and Casa, and you could just do peer-to-peer sharing. So some of you might know it. You could burn the CD at home. You would buy the device. So you open this program. You would find another user who had your song. You would kind of do peer-to-peer sharing, and you would have your CD. You didn't need to buy any CD. So I don't have the details about the lawsuit. Maybe you know much more about than me about this, if you want to share more. But basically what happened a few years later, now we have Spotify. So probably most of you have some sort of streaming app in your phone. So when you're walking, you're doing something, you listen, it's perfectly legal. So Spotify is one example. There are many others. So basically the whole industry changed. So it started illegally, started strange, started breaking the law, but then kinds of things settled down, and now we have a business model such as Spotify. So the founder of Suno, I think it's the founder of Suno, either Suno, I think it's Suno's founder, he's saying, we are the revolution. AI is changing everything. AI is changing how we work, how we do everything, how we design, how we get more productive. So AI is also changing the music industry. We are this new revolution. You can use our AI system to create whatever music you want. Before, you needed to learn music to be a proper musician, to create excellent music. Now you don't need that anymore. You just use our AI system. Now anyone, even if you are a shower singer, you can, with a few prompts, you can become a musician. That's the future. And the record labels, they envy us. They want a share of our pie. They don't want us to steal their income. So that's the only reason. They're not the good guys. They're even exploiting the artists. So we are the good guys. We are democratizing music. And the same way that it happened many times in the music industry, we are here. We are this new world of AI music. So this is, I think, is the only one of the lawsuits where the founders are straightforward. That's it. We are the new generation. You guys are the old guys, bad guys. So don't try to sue us because you're not doing good for anyone. So what are your thoughts on this one?
Yeah, it's fascinating. We're talking just before the recording started, and I was absolutely fascinated by this case because if there is a copyright industry that you don't want to mess with, is the music industry, and we've had years and years and years of experience of this. And I kept thinking there must be a twist, there must be some surprise, they must have an ace up their sleeve, that they're going to make a clever argument that they know they actually haven't been using any music from commercial producers, that they're all getting all their music from 1920s that is all in the public domain. I was expecting something, because I was really surprised that someone would enter this space against the music industry knowing that they were going to get sued. And yes, they got sued. Obviously, that was evident. And also, in their defense, they didn't produce any ice up their sleeve. They said, well, what they're doing is fair use. And I think, looking at the test for fair use, this is probably one of the weakest ones. I wouldn't be surprised. I'm not a betting man, but I would not bet against the music industry here. But as you mentioned, it looks like what they're trying to do is precisely disrupt. Is disrupt the market, is to be in this space where you're saying you are all dinosaurs and we're going to jump over you in the evolutionary change, or all sorts of arguments that these people are making. Because for them, the argument is the disruption, is they are going to get rich no matter what from all the venture capital money that they're getting, and just it's like throwing a grenade into I don't know, I don't want to say nasty things, but it is trying to disrupt. They're trying to, the idea is precisely to disrupt. And I think that of all of the cases, there are different strengths in the defenses. I honestly believe that this is probably the weakest, and I wouldn't be surprised if this was one of the first ones that get decided, because I think it's the fair use argument is weaker, but also the argument from the copyright holders is much stronger.
Let's move to thank you, Andres. And just before we move, actually, and in this one about against Suno, so they say Udio and Suno, they keep saying that the output is always a new song, right? They say we never output copyrighted work. So our song, the output is always a new song. So yeah, and it's interesting again to go back to the fair use test. So can they keep this argument? Okay, you train it with the and it's interesting that they say two things in the law. So that they say we use publicly available songs. So I always think it's interesting how AI companies, they conflate public domain with publicly available, right? So they are creating this new legal concept that I found it on Google, or I found it on the internet. It is the same as public domain, so it's not. It's one thing, and they always say we are doing what everyone else is doing. So this is interesting. So one company after the other. So we are doing it. So we are all a group of people doing these new things. So maybe
just to complement that, it's also important to think with all of these lawsuits with something that we haven't mentioned. These companies are not only competing with the copyright holders that are suing them. They're also competing sometimes amongst themselves. And it's interesting also to look who is getting sued, but also to look who is not getting sued. Because we are looking at all these 34, 35 cases that are usually against the same companies. And for example, Grok, still going. Very interesting political discussions here. So yeah, and all of these companies are doing this in the background, even if they're not releasing models themselves, they're all doing some training in the background.
And let's talk about the last one in the US, which is a bit different, and I think many in the audience are going to be interested. So it's Jason Allen versus US Copyright Office. So what happened here is that this Jason Allen, he's an artist, and he says that he uses AI to create his art. So he created this image called Théâtre d'Opéra Spatial, so this theater of spatial opera, and he wanted to receive copyright protection. So he went to the US Copyright Office. So he said, I want to receive copyright protection. And the US Copyright Office answered that his AI work lacked human authorship. So he could not receive copyright protection. And then he's now suing the US Copyright Office. He's saying, I deserve copyright protection. And the interesting argument here, and it's a really interesting lawsuit here, he uses Midjourney to create his artworks. And he said that to create this specific one, this Théâtre d'Opéra Spatial, he prompted Midjourney 624 times. And he says that first he says if you have used Midjourney, it takes some time. So every time you prompt is not immediate, it's not seconds, sometimes 1 minute. Have to wait until the output comes. So 624 prompts means a lot of minutes waiting for the next outcome. And he says that he became kind of a specialist. He's like a pilot. He learned a technique to prompt Midjourney to make Midjourney output exactly what he wants. So as if let's do an analogy here. So he's like a painter with learning how to use the brush. So Midjourney is just the brush. He became a specialist in Midjourney prompting. And he has this special technique. That's why, and he's trying to justify his authorship, so that he should receive, so that he receives copyright protection over his AI work. So a few questions on this for you. So first, what do you think of that? So is it a number? So first, AI art, can it ever receive copyright protection? What is the level of human authorship? So 624 prompts, is it enough? 10 prompts, 1,000 prompts? Is it about the number of prompts? Is there any way to measure? So some people say, yeah, we have to verify, if you have to look at the final work and see how much human. Is it even possible when we talk about art, AI art?
Yes, this is going to be an interesting one because we are starting to see fewer cases on the authorship side, the creative side of AI, not as many as the infringement cases, which is very interesting for me. Initially, actually, it used to be the opposite. People were more interested in the copyright authorship debate more than on the infringement side at the start. Then all the lawsuits started flying, and the things changed. So the Jason Allen case is very interesting because the U.S. has this system of registration, and in their guidelines, it says that a work that has been generated by a computer cannot be registered, doesn't have copyright, and it's in the guidelines. So that's why Jason Allen got he admitted that this work, by the way, it won an award in Colorado State Fair. It won on the digital art category. So
well, he should just keep getting awards and forget about copyright, right? So
exactly, and I think it's more of a principle, which is something that we are starting to see with some of the authorship cases. So he got the application rejected, then appealed to internal board of the U.S. Copyright Office, got that rejected, and then sued Sierra Perlmutter, the registrar of the copyright. The case is ongoing. I don't know, to be honest. If we look at the history of these cases, potentially I don't think that there is a very good chance that he'll be successful. He'll have to prove that the amount of work that he exercised was quite a lot, and that the computer just was following his instructions. In his complaint, he says very much, I use Photoshop, I use Gigapixel, I use other tools, and this is what digital artists do all the time. We use Photoshop, and it's been accepted that Photoshop is the same thing. So there has been his argument. The problem that he has is that there's already a decision on this, which is on Stephen Thaler and the controller of, and Permuter. And Stephen Thaler is super famous in AI IP circles because he's a scientist that invented a machine, Davos, that produced three inventions and applied for patents all around the world, and has been suing patent offices all around the world to get his invention declared, the machine declared as an inventor. He also created a machine that created a painting, and the painting, he tried to get the machine declared as the artist, and he lost. The case was dismissed, and then sued, lost the case, and is now under appeal. And there was a hearing, and the hearing didn't go very well. So everyone is expecting that he's going to lose that case. So because of that precedent, it's possible that Jason Allen is also going to lose the case. Now, this is going to be very jurisdiction specific, because in China there have already been a couple of cases where AI works have been granted copyright protection. So you mentioned it was like 600 and so minutes. By the way, Jason, people dispute that apparently there are contradictions in this argument, so that may play against.
So how do you prove, right? So you take a screenshot, you have to. So
Yeah.
it's even there's also, I would say, a procedural issue here. So will the U.S. Copyright Office then evaluate 624 screenshots and I don't know. But,
Yeah,
but do you also think that Jason is trying to kind of make a statement? He's trying to, the same way that Udio and Suno, they want to kind of say, music has changed, so Jason wants to say art has changed, so I'm the new artist.
This is more, it's the same with the Stephen Thaler lawsuits. They are trying to push the envelope. They're more like lawsuits that are less about their own copyright, because I don't think that something that we have been learning is that particularly with art, is that it's not very valuable. So what's the point of having copyright? You know, you can just keep churning out images or text. So something that has been sort of changing the narrative when it comes to authorship or giving copyright to these machines is that, okay, someone is copying my work, I'll just produce 10,000 more, or whatever. It is. It has become almost like a matter of pride not to try to get copyright. And people like Jason Allen or Stephen Thaler are actually trying to push the envelope, trying to change the narrative again. So we've had two cases in China. Outside of that, not a lot of case law. And I think that the argument, and I'm probably going to be on the losing side here, because I was someone who said, maybe we should give copyright to some works. I'm happy to say that I'm probably going to be found to be wrong on that one. I said, well, maybe. But that was before AI slop and all sorts of things started happening. So now I think that what has happened is that a lot of the debate has moved on, and particularly the value that people give to generated works is seen as less. What may be interesting is potentially, what may happen is that people may start using more AI in their creations and not disclose it, which is tricky.
But still receive copyright protection? No, and still receive copyright protection?
Yeah, because my argument before was a practical one, is we don't have a copyright police. We're not going to have someone just making behind you at all times trying to see if you use AI in writing a song or writing lyrics or an artwork. So unless we start, it's going to become very difficult, particularly as these tools are going to become more and more out there. More people are, and potentially already, we are consuming media that has been using AI and we don't know. So that is potentially the only thing that I think may change the debate. But for now, there is not a lot of stomach for people to actually accept copyright of AI-generated works. There is, I think that the debate is over for the most part. It's not going to happen. Most systems, even the UK, which had a historic provision on this, Section 9.3 of the Copyright Designs and Patents Act, the government is currently discussing potentially going to get rid of that. So we don't know. But I repeat this, potentially what's going to happen is that people will just use it and they don't disclose it, which may be an interesting question. If we're going to value, not if, right, we value human creativity more, what's going to happen is potentially proof of humanity certificates, some form of, I don't know, legal requirement for you to disclose whether or not you used AI. There have been hints of this already, particularly when it comes to deepfakes. So yeah, it's interesting. I think that where we are now on the authorship question has moved from 2 years ago completely. And going back to Jason Allen, I think there's a very high possibility that he will lose that case.
And in terms of, you were commenting now on people using AI and not disclosing it, I think so. Just before we talk about solutions, we finish our talk with the more positive side. So where can we move from this all litigation? Maybe litigation is not a solution. So what could we do? But on this topic of AI art and human art, what I feel that is already happening. So now we have so many tools. So we have, Grammarly, ChatGPT. Everybody checks all the text, and I post on LinkedIn. You see the comments, and it's very clear when it's AI generated. Yeah. Mostly, I see more on LinkedIn. I think on Twitter or other people would make fun, but it's a lot of posts and everything that you if you have ever used ChatGPT, you look at it, when it's AI generated, and it's so boring. What I feel it's happening already, just because people are everybody's writing with the same way. Before, writing is a way to express yourself. Both art and writing and any type of expression used to be a way to express ourselves with our specific talents, our manners, and our style. And now, if people use AI to create images, AI to write text, everything is standardized, and everybody's posts on LinkedIn, they look the same, and other places as well. So I think more and more, this is kind of a cultural reaction, and I see that already happening slowly, and probably it's going to get more and more as AI spreads. We are going to fall in love again for everything that is raw, human, with mistakes. People will start publishing articles full of mistakes on purpose. You have to add mistakes. Sometimes I read my newsletter twice, and I start being a bit perfectionist, and I say, but then it will look like AI. Maybe I should have left that. Yeah. I'm Brazilian. I'm not a native. So why do I want to write native? So maybe I should add mistakes. I feel it's become a bit boring. So might become this is from a cultural perspective. I feel that. I already feel that it's so boring sometimes, but everybody uses the same AI tools to write perfectly. So where is the diversity? Where is the beauty of expression?
Yeah, I've been using it to check my grammar mostly because, again, like you, I'm not a native English speaker. But I was checking grammar on specific things, but I never used the output because it changed my voice. I have a very specific voice. I like how I write. And maybe it's a bit quirky, maybe not everybody likes it, but I have a specific quirky sense of humor.
Besides litigation that we are seeing, so how can we solve the problem? And what I mean by solving the problem, so how we can make sure that creators, artists, anyone that produces content can be compensated, can have their autonomy respected, or their if they don't want to have their art or their books or whatever copyrighted work to train AI, they should be respected. So this would be solving the problem. And also, if for those that have already had their copyrighted works to train AI, perhaps have some sort of compensation, I don't know, going backwards or from now on. And so some ideas. So I sent to Andres, so we can talk about some of them. So fair training certifications, licensing deals, creator partnerships. So having some sort of, if you are a creator and you want to have your work used to train AI, so you can kind of sign up for some sort of platform. I have heard of solutions aligned with output revenue sharing. So if some sort of technical tools to say that, yes, your work was used to produce this output, so you get some sort of a small compensation for the output, stronger opt-out mechanism. So what are your thoughts on that?
So I think that there is going to be a multifaceted response. I think that I've been thinking very because I've been looking at internet regulation and the history of internet regulation. It's that usually big technologies, the internet sharing technologies, platforms, social media, come with a bunch of lawsuits, and then we start getting legal solutions. So I think it's potentially going to be a number of solutions. One is possibly going to be legislative. So usually that is the first. The first is actually going to be the case law. So we're going to start seeing the cases happening, and my guess is that we're going to get a 50-50 split at first, but it's going to take a few years for us to get eventually there. So that is the first one, cases, then legislation to respond to the cases. And then we're going to start seeing licensing deals, particularly with collective societies, with large collective bodies. We're starting to see some of them flexing their muscle. GEMA, the German music collecting society, is already suing OpenAI, and I think that they're trying to do this for two reasons. One is to sort of to test the opt-out regime in Europe, but also to start testing what licensing agreements are going to look like. I am less bullish or less positive about things like output sharing or compensation regimes, because I think, at least at the moment, with the technology that we have right now, it is almost impossible to find out what were the inputs or what inputs were used in the creation of the work. And at least in images, it's not possible. I think potentially in music, maybe more possible, but it is very difficult to do something like that. So I think potentially organization from the creators to get together, because it's going to be very important, collective management, but also collective bargaining. It's going to be very difficult for individual artists, individual creators to try to negotiate individually. I think that this is something that we've learned from history, is that collective management and collective bargaining and negotiation tends to work better. So
And just
I think that is
audience a little bit about what licensing deals. I think some people in the audience might not know exactly what are those licensing deals. So if I can also clarify. So for example, there have been already some licensing deals. So one example is Reddit. I think Reddit, they have a deal with both Google and OpenAI. I think with Google was $60 million, the speculated value. So it's basically a licensing deal. You have a company or a collective of artists or an organization, and they're going to set a price. So if you want to use our content to train your model, so let's imagine you pay, like, I think what Reddit was, a $60 million a year. So you pay us $60 million a year, and you're going to have the right to use whatever is in our platform. You can ingest it and do your AI training. So this is for those in the audience, this is the type of licensing deal. So you have this contract that will set the terms, but basically you pay the AI company will pay to have access to some sort of content to train the AI model or the AI system.
Mm-hmm. Yeah, Another example is in academia, academic publishing. As you mentioned, I'm an editor of a journal, of a law journal. Our mm, parent company, Wiley, um, already agreed to undisclosed amount of money to um, for AI training. So a lot of our academic articles are already being trained on.
And questions, did they ask for consent of each author? What, there
No,
was some sort
because
of email,
oh
hey author,
yeah, oh
anything?
you're opening another can of worms. Academic publishing is another crazy subject. Um, for the most part, whenever you publish with an academic journal, you are either giving away your copyright or granting them permission to do whatever they want. So
Okay, so was already,
no, they don't need to ask any of the authors, which is
maybe they wanted to be extremely transparent, right? And say, hey authors, maybe if you don't like it anymore, you could delete. But they're
yeah,
all,
yeah.
and
But then our
and
jobs are tied to this. So
exactly. But on the
yeah,
licensing, I think it's an interesting aspect. It interests me a lot. So the transparency part. So licensing deals, for example, Reddit is a good example. So they have this licensing deal with Google and I think OpenAI too. But then what happens with the creators, right? And the people that are there. So Anders was talking about the academic journals, but the other social media, when social media licenses the content. So shouldn't the people that are there, the people, when you join a social media, and with Meta it's interesting what they're doing, right? So it's a very interesting intersection between data protection and copyright and I would say creators right and data protection rights. So when you join a social media, your idea is not that you're there to offer your content to train AI. You're supposedly join a social media to share content, to connect with people. And now what's happening at the background is, okay, there are those licensing deals, which might be a solution for the copyright problem. But then there are all sorts of transparency issues and data protection. So what I didn't sign up for that, right? I'm at a blogging platform. I'm blogging here because I want to blog, not because I want to offer my content to train AI. And then they would say, yeah, but is your contract with me? And then you have to change your platform. There are all sorts of issues with changing platforms. The debate is very polarized, right? We discussed this, that the
yeah.
artists and authors, they are angry that their copyrighted work, it
Mhm.
took so many years and so much effort to produce it. Then suddenly comes an AI company, says, hey, I want to digest everything to train my model for profit. I'm not compensating you. I'm not asking for your consent. I'm just doing that because I can. And I have enough money, infinite money to litigate. If you can litigate, and there are much deeper pockets than whatever collective organizations, right? So the most powerful companies in the world. So rightfully so, it's a very polarized debate, and people, artists, creators are angry. So my first question is, are you optimistic? Will there be any point in time where both sides will be happy? Are we going to find a solution? And a
Yeah.
nice parallel here is what we spoke about, the music industry. So I would say Spotify. I know that many artists, they are angry with Spotify. They think that the Spotify fee is too high, right? So, and other platforms fees are too high. But I would say we do not see litigation anymore, right? It's kind of it has settled down. I see many artists are angry, but it has kind of settled down. So do you see something like that happening? One, we will. When are we going to get to that point? Is it 2025? Do you from what you've been observing, will it take 5 years, 10 years? How long it will take to settle down?
Yeah, uh, I think that things will settle. Things will always settle. Nature abhors chaos. Well, at least legal uh, nature abhors chaos. At some point, we're going to find a plateau in which businesses can develop, and also creators and artists feel that they are getting at least fair compensation. You mentioned a Spotify system. I still think that potentially a collective licensing deals is going to go to be where we are headed eventually. But yeah, things will settle. The lawsuits will be either settled, decided, or going all the way to the U.S. Supreme Court or the Court of Justice of the European Union, or things are going to calm down at some point. And what is going to be left after, I have no idea. If I knew, I wouldn't be talking to you. I would be in a yacht out in the sea, enjoying margaritas. Um,
You're almost
my
there.
guess,
Almost there. You're enjoying
well,
this
I'm almost
beautiful.
there. Yeah, I'm right. I'm right at the beach. Now, uh, my sense is that things will equalize. Whether or not everyone will be happy, it's more difficult to tell because, as you mentioned, tech companies have all the power, all the lawyers. Again, I repeat, not everyone is getting sued. So it would be perfectly possible for most of the companies that are getting sued at the moment to disappear tomorrow, and AI would still continue because there will always be someone to the uh, take the slack. Tech companies are very much into this. Governments are starting to be very much into this. I saw, sorry, I've been sort of ignoring the comments a little bit, but I saw someone mention the UK government just today published a very bullish AI uh, paper with 50 actions, and one of them is completely pro TDM exceptions. So there is governments are starting to see, this is a big selling point. The U.S. government, we haven't even discussed this. The U.S. government is now a technocracy with Elon Musk and Mark Zuckerberg sucking up to Donald Trump. So the tech giants are on the move and they are accruing more power. There is that is the reality in which we're going. We haven't even talked. Yeah, what a Trump administration, a very pro AI tech administration, Trump administration will mean. We haven't even begin thinking about that. And so it is very difficult to see how things would move. But I want to finish in a positive note. I'm a very positive, optimistic person. I think that eventually things are going to happen that we have been seeing, talking and saying in the chat. I used to make lots of images on with artificial intelligence. I found it very fun, very interesting. I don't do that as much anymore. Sometimes I do. It's because there is almost like as we were talking, there is almost like a sense that you're cheating, that you're that I think that the slop is a good description of this. A lot of AI is now being tarnished as slop, and we are going potentially to see AI in the AI industry to grow, but again, more creators, more artists, more musicians selling their reality, their rawness, as you were saying, and potentially that is going to be uh, the way forward. However, that will depend on us, the media that we consume, mm, the choices that we make individually, and I don't think that that is a copyright issue. That is a society issue in general. If our politicians are moving full speed ahead with AI, what are we going to do as users? Is there enough stomach for a revolution on this topic? But at least I think that on the short term, licensing deals is where we should be headed, at least for now. People getting compensation, people getting an idea, or at least a recognition of their hard effort, that the effort that they have put in the creating their works. And I think that that's where collective management, collective bargaining is going to come in. I would like to finish with a more positive note, but I think at least for now, this is where I see things heading. As for the time frame, the lawsuits are going to take years, particularly the U.S. lawsuits. And we're talking sometimes if they go all the way to appeal and Supreme Court, and particularly some of the more difficult cases like the Authors Guild, some of the cases that we haven't even discussed, Getty, Authors Guild, those have the potential to be 10-year litigation. Some of the cases we're starting to see in Europe. There is the Lion case. We haven't even talked about Europe.
Yeah, because
or the
I
UK or
thought,
all.
yeah,
Yeah,
I
my
just
God,
keep.
we haven't even covered half of the interesting things happening. Some of these lawsuits are potentially going to be appealed all the way to the Court of Justice of the European Union. So, it's a great time to be a copyright academic. I'm having the time of my life. I can tell you about it. I'm a nerd, so that's what I love. Writing about this, I love teaching about this, I love thinking about this all the time.
So this is a very positive way to finish. So where can people find you in this? Where are you right now? So LinkedIn?
Yeah, on LinkedIn, very easy to find Andres Guadamuz. I apologize to all of the other Andres Guadamuzes of the world, but I usually come up very high in the searches. And Technolama, my blog, technolama.co.uk, and I'm Technolama on Blue Sky and Twitter. I refuse to call it X.
Okay. So everybody should check. So you have been publishing in Technolama about AI copyright too, right? So your recent articles were more about AI copyright, and now you also publish sometimes academic articles. There were a few.
Yeah. I've been getting one on authorship, which is my most cited work so far. One on the infringement question, and just recently one on the AI Act and what the potential implications for copyright may be. And I already have to write another one because we've had a code of conduct that has made very interesting choices on some of the copyright issues.
Thank you very much. It was a pleasure. Thank you for connecting from Costa Rica, from the beach, and you accepting my invitation. It's a pleasure. So thank you, everyone. And 2 reminders. So check Technolama, subscribe to my newsletter if you want to stay up to date with everything AI governance, and also get notified about the next AI governance talks. If you want to join the next AI governance training in February, so register soon. The website is under my name. And see everyone in February with the next live talk. Thank you, everyone. Thank you, Andres. Bye-bye.
Bye.